Welcome to today's program titled Getting Texas Back to Work, Practical Tips and Legal Risks as Businesses Reopen. This time all participants are in a listen-only mode. Those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Steve Shardanovsky. Steve, you may begin.
Thank you very much, Monica. Well, good morning, everybody. We're happy to have you. We've got a great webinar for you today. We've got a little bit of a disclaimer to start off with. My name is Steve Shardanovsky. I am a partner and the chair of the Labor and Employment Group here in our Houston office, and along with my colleagues Chris and Linda and Tim, we're going to be taking you through some issue spotting and a discussion on really some important topics and ideas to think about as you return your employees to work, either reopening your businesses or bringing employees that have been working remotely back to your workplaces. We've got, at last count, about 350 RSVPs for the webinar. We're going to do our best to take some questions at the end of our presentation if we do have time. Let's talk a little bit about the status of Texas and reopening businesses here in the state. As most of you know, Governor Abbott last week issued his plan for the first phase of reopening. And while he calls it a reopening, there's not much that has changed for businesses that have already been continuing operations, right, as essential workers or essential businesses. What's changed really is this narrow band of reopened businesses that are mostly retailers, right, and restaurants as well. But everybody else still needs to either continue to work from home or continue to have closed, shut down operations. For those retailers that are reopening, that have reopened this week and that are going to continue to reopen, right, they have a limit of 25% capacity or occupancy. The other important piece of the puzzle from Governor Abbott's plan really has to do with the phased reopening, right? So the first phase started last week. Even a few days ago, on May 5th, things have changed as well. A few days ago, Governor Abbott announced that nail salons and barber shops and other venues like wedding venues can start to reopen as early as tomorrow. Bars and gyms and pools and other types of recreational facilities likely will not reopen until later this month in phase 2. We still don't know when Governor Abbott is going to open up sort of office-type businesses or other businesses that are not essential, don't fall into the essential services. We expect that that's going to happen later this month in May or possibly into June. It's really a huge unknown at this point. What we do know, however, is that a lot of the counties are still requiring most businesses to remain closed, right? So if you're not an essential business, or if you're not one of those retail outlets or museums or libraries that are being allowed to reopen under Governor Abbott's order, then under a lot of the local executive orders, you must remain closed. Right, so that's certainly the case in Harris County. That's certainly the case in Bexar County, Dallas, Tarrant, a lot of other large counties. For businesses that can continue to operate, all of these orders require that you continue to follow social distancing guidelines, right? And there are other requirements that apply outside of the workplace. So, for example, in Harris County, if you are in a household and somebody in your household tests positive, all of the residents in that household must self-quarantine until cleared by either state authorities or by a healthcare provider. And the Harris County order also does require employees, those out in public, to wear masks or face coverings. I know there was a big uproar about that a week or so ago. The initial order imposed civil penalties and potential criminal penalties for failing to wear face masks or face coverings, but Governor Abbott's order essentially did away with the enforcement mechanism. But masks and face coverings are still very much recommended. I'm going to spend a little bit of time here talking about safety protocols for return to work, but that really is only a small part of your return to work plan, or putting together a comprehensive return to work plan, right? Not only do you have to think about the safety protocols and health and safety policies to amend, but think about all of the updates and the changes that you might need to make to your handbook or your policies with respect to all of the different new leave and paid leave laws that have come out, right? Think about the process that you're going to take to determine which employees are going to return to work. How are you going to select them, right? And when they do come in, how are you going to make sure that they're safe to return to work, right? So Linda later on is going to talk about health screens, medical screening for employees, right? And it's not just employees, right? You have to think about the vendors and the contractors and the visitors that are coming into your work sites, and put together a plan to determine whether you're going to screen those individuals as well and how you're going to do that. Before you return your employees to the workplace, think about putting a plan in place to bring to an orderly close all of the work that's been done remotely, right? Do you have employees that have taken equipment home or documents home or confidential information that they need to bring back, right? You have non-exempt employees or other employees, exempt employees that have been working remotely, right? You want to verify that during all this time that they were paid correctly, they tracked their time correctly, that they've taken all their meal breaks. Think about how to certify that when they return to the workplace. So there are a whole host of other issues besides safety that you ought to consider before returning employees back to work. And we've done really all the hard work for you. At the bottom left of the screen here, you'll have a link to our return to work checklist. It's sort of a 30-page guide of all the issues, legal, practical, compliance issues to think about as you return to work. But we're going to focus right now for a few minutes on the safety protocols. Now, there's really no one-size-fits-all plan for implementing safety protocols when your employees return to work. A lot of these the decisions are going to have to be made on a case-by-case basis. You're going to have to, it might depend on industry-specific standards. So, for example, if you're a consumer-facing company, right, what are the safety protocols that you're going to think about to protect your employees from the customers that walk into your door? And vice versa, what are the safety protocols that you're going to implement to protect your customers from your employees or for potentially getting exposed at your place of business? The same thing with in other industries, right? For industrial or manufacturing and construction, OSHA recently put out industry-specific guidelines. So depending on the configuration of your workplace, depending on your industry, there's going to be different factors that you're going to have to consider. But the place to start really is with the governor's reopening plan, right, and his executive order. At least for Texas employers, right, the minimum requirements that the plan sets out is for you to follow the protocols and the recommendation from the Texas Department of State Health Services, the guidelines that have been issued by the CDC and OSHA. his plan also encourages but doesn't require workers and those out in public to wear appropriate face coverings, right? And there's a couple of other tricky issues for multi-state employers, right? While the executive orders that have been issued by the governor here in Texas and local authorities in the counties here in Harris, other large counties, largely have been tracking the state's requirements. But that's not the case in other states. So if you're a multi-state employer, there really is sometimes a confusing patchwork of different executive orders with different requirements, different restrictions. And you also, as I said, have to comply and look out for industry-specific guidance. There are so many good reasons to comply, right? Not only is it the law, right, in terms of OSHA requirements, but it's potential defense to negligence claims, right? At least in Texas, employers that are non-subscribers to the Texas Workers' Compensation Act, right, can be sued by their employees for negligence. But even if you are covered by workers' comp here in Texas, there are exceptions, right? There are gross negligence exceptions for wrongful death claims here in Texas, and if the injury was substantially certain to occur, your workers, even if you have workers' comp, may be able to sue you for negligence. There's plenty of good reasons to comply with the safety protocols. So what are some of the minimum safety protocols you should consider implementing? We've all heard about social distancing, but it really requires attention to detail and to your particular workplace, right? Modifications to the workplace, making sure that folks maintain the 6-foot distancing guidelines, implementing maybe one-way hallways, right, or barriers in between workstations, reducing in-person meetings, right? We've all been having more video conferences, closing down break rooms or limiting the number of employees that are allowed at any one time in the break rooms. There are a whole host of other safety protocols to consider, including safe screening for employees and customers. Linda's going to talk about that, providing appropriate protective equipment to your workers depending on the industry, providing cleaning and sanitation, right, equipment for your employees, whether that's wipes, having the workstations cleaned regularly, a whole host of ideas that you should consider implementing. Again, this is an overview, but our partners yesterday did a whole 1-hour webinar, a full 1-hour webinar on safety protocols, and we'll have that link for you at the end of the presentation. So where should you start? Well, a great place to start is OSHA's 10 steps to reducing exposure. A lot of you may have heard of these before, but this is a great place to start. And there are other great resources available, right? The Texas Department of Health State Service checklists are an excellent resource to start with. You can find them at the link here provided on the slide here on the bottom left of the slide. The state agency also has industry-specific protocols, right? So not only do they have checklists for your employees, but they also have very helpful checklists to use with customers and vendors and contractors when they visit your work site. Another great resource is the Houston Greater Partnership. They have put together, in conjunction with Houston businesses and government leaders, 15 principles to reopening safely. Another great resource for you to look at. And if you're looking for templates, guides, and best practices that are industry specific, the Houston Greater Partnership also has you covered there at the link here provided in this slide. There's industry-specific samples and templates for healthcare, right? For oil and gas, for industrial sectors. A lot of great resources for you to use. And in the next section, I'll hand it off to Linda. She's going to be talking about some specific safety protocols relating to medical exams and dealing with workers who may not want to come back to work. Linda?
Thank you, Steve.
Good morning, everyone. So many of you are in businesses that have been having employees work remotely, or if the work could not be done remotely, putting them on furlough or layoff. And as Steve said, the time is coming for those folks to come back to work. So I'm going to talk primarily about the logistics of doing that and the issues. Steve showed you this checklist, the checklist for all employers put out by the state of Texas. It's a little difficult to read, I'm sure, on the screen. But essentially, and this is not mandatory, but it certainly is going to be the standard by which you are judged if anything goes wrong. You have to train employees on appropriate cleaning and disinfection, hand hygiene, and respiratory etiquette. You have to screen employees before coming into the business, and I'm going to stop there. So, logistics, who's going to do that? Where are you going to do that? Later on in this particular checklist, you'll see that people are supposed to go and wash their hands when they enter the workplace. So all of you who are in charge of figuring out how to implement this are going to have to designate people, develop a process. I have this vision of this line of people coming into the workplace, which was not set up for this at all. And, is there going to be hand washing followed by screening? When's the training going to take place? And then, of course, if people flunk the training, you need to send them home. They can't come back unless and until. All of the guidelines are in here. This is going to be a large burden on employers. And then you're also going to have the employees who don't want to come back for many reasons if they've been on furlough collecting unemployment benefits. One of the largest reasons for not wanting to return for our lower paid workforce is the fact they're getting more money than they would be getting on they're getting more money on unemployment than they would be getting at work because of the very generous federal benefit of $600 a week. And a lot of people have reacted negatively to that one-size-fits-all $600, but there was no way, with all of the unemployment claims being filed, to actually be able to screen people to figure out who was going to get more or less than they were actually making. So if you have lower paid employees, they have a tremendous incentive to stay home. The state of Texas came out with a very significant change in the rules for collecting unemployment benefits. Generally, if you have employees on furlough and you are reopening and you recall them to work and they refuse to come back, they would be disqualified from receiving any future unemployment benefits. Not so if they have a qualifying reason for refusing to return to work. Everybody age 65 plus gets a pass here if they have a household member at high risk, if they have the virus and are not recovered, if they have a family member with the virus not recovered, and there's a 14-day window there, they're currently in a 14-day quarantine due to exposure, or their children's school or daycare is closed and no alternatives are available. And I think it's fair to say that every school in the state of Texas is closed and will be closed for a while. So employees that you want to have come back may have a justifiable reason for not returning and still being able to collect unemployment benefits. There is no requirement, however, that you give them job protection unless there is some qualifying reason in another law, like they're on FMLA because of their own serious health condition. But it's going to be a challenge for employees to weigh the risk of, I can collect the benefit. It's making my life much easier because my 4 kids are home from school, and I can collect more than I make normally. And I don't have to, pay anybody to watch them. This works for me. However, the thing they have to balance against is there may not be a job to return to. So these are very difficult times for everyone. And I think in addition to following the laws, which are really difficult because they seem to change every week to 10 days, this is a time of compassion. Don't rush to terminate if the workers refuse to return, and keep in communication with them. So back to the screening. It's amazing how things change when we have a pandemic. The EEOC jumped right into the middle of this, right at the beginning, and said you can take people's temperatures. That would normally be a prohibited medical examination. But you have to do this in a private way. You have to maintain social distancing. You have to follow guidelines, and also keep in mind this is not a surefire diagnostic test because there are many people suffering from the virus who don't have fevers. And again, going back to my issue with logistics, who's going to do this? What are you going to do with the information you collect? Because as we talk about these medical issues, you all know that you get into HIPAA issues, you get into data privacy issues. I've seen just, every time there's something terrible that happens, new businesses are created. And I've seen a lot of apps where this information can be gathered from employees. And be very, very cautious about jumping into that. What else could you do? Well, you could do the blood oxygen level testing, because there is medical evidence that a low oxygen level is an early indicator of the virus. But this is not something the EEOC has addressed specifically, and there are many, many reasons why a person's blood oxygen levels may be low. COVID testing. You can test everybody. You have this great line coming into the workplace, and everybody gets a COVID test. Well, you have to use a test that's accurate and reliable in accordance with the FDA guidance, the CDC, public health guidance. And the other challenge here is you have to consider the incidence of false positives or false negatives. Antibody testing. This is sort of a new wave that's come. And again, the EEOC has not spoken directly. I think it would be permitted under the same rules and terms as for COVID testing. The pros and cons of such tests. Okay, so it's another test you have to administer at the beginning of the workday. There's a high false positive negative rate. An antibody test will reveal that maybe someone had it before. That's a good thing for their own comfort, but I don't know that it is going to be helpful to employers. Now, I saw someone ask the question about providing training. So I am not going to conduct a class on face coverings this morning. However, I put these slides in to give you an example of the kind of information you could distribute to your employees. And I learned a great deal about how to wear face coverings. Apparently, there is a particular way you have to do it. So I'm just going to go through those slides. I also learned a great deal about the care and disposal of disposable face coverings. Again, this is a tool you can use in terms of training to answer one of the questions that was asked. All right, so now the future. Many, many companies took the position that it was not reasonable to accommodate a person with a disability who requested to work remotely. Now, I don't know if anybody's chuckling right now, but that undue hardship defense can be a big problem for future requests to work remotely when there's all kinds of evidence that your business seemed to do just fine for a number of months. Of course, the reasonable accommodation piece only applies to persons with disabilities. But again, let's step back from all of this. We need to work with our employees in a compassionate way at this time. Many of them have been off on furlough, have had not a lot to do, and all they've seen is constant news coverage. So they're a little anxious about coming back to work anyway. Many of them have childcare issues, transportation challenges. Some of them don't want to get on buses, and they don't have a vehicle that they can use to come to the workplace with. Also, think about it from the employer's point of view that it could be a plus. If it's been working pretty well, the fewer people you bring back, the fewer you have to train, test, monitor, et cetera, et cetera. So I'm turning it over to my colleague, Chris.
Linda. So Linda has talked about the ADA responsibilities with respect to employees. I'm going to be talking about public accommodations under the Americans with Disabilities Act, which is more about how you think about that with respect to customers or visitors to your business. Now, before I do that, I'm going to give you guys the CLE or the HRCI code. Go ahead and grab your pen so you can write it down. I'm going to give the code at least twice. The code is SS as in Seyfarth Shaw 3661. That's SS as in Seyfarth Shaw 3661. So I'm not going to do a complete rehash of Title III of the Americans with Disabilities Act, but instead I'm going to give you a quick overview of the most important elements in the context of the pandemic. And then I'm going to go over some actions that businesses, particularly our essential service businesses, have taken already. And so we can talk about that in the context of concrete examples that people have done and what may happen with those concrete examples as we move forward. And then I'm going to be talking about how you should think about accommodations going forward and how you may want to develop policies to address the needs of persons with disabilities as they start to come back to your business. So the ADA requires that public accommodations, and there's about 12 different types of public accommodations under the law, but you should generally think of that as if you are selling something or offering a service or feeding people and that in exchange for money, giving hotel accommodations. All of those are public accommodations. And generally, when we think about Title III of the ADA, most of us are familiar with the physical accommodations that must be offered to persons with disabilities. So, for example, when you go to a mall, there's a lot of parking spaces reserved for persons with mobility impairments. That is part of the Title III of the ADA. But I'm not going to be talking about those physical requirements, but instead I'm going to be talking a lot more about reasonable modification, the requirement of under the ADA that you reasonably modify policies, practices, and procedures for customers with disabilities so that they can access your goods and services. There's also an effective communication and use of auxiliary aids of services, and we're going to talk about that in the context of websites. Just in case you didn't know, there is a private right of action under Title III of the ADA. It provides for injunctive and declaratory relief, so you can be required to comply with the ADA by a court. There is no damages provision under the federal law, but there is a right to attorney's fees and costs for the prevailing party. There's also, the DOJ also has a role of enforcement. That is far less common than the private right of action, but just in case you come across it, it can be very upsetting to businesses. The DOJ can impose civil penalties, require a consent decree to settle the action, and impose other monetary penalties. In addition, Section 508 of the Rehab Act, for those of you who receive federal funds and are open to the public, imposes similar requirements. The ADA is different because it's one of the few anti-discrimination laws that require affirmative steps by businesses to ensure access to persons with disabilities. There are some limits on the type of affirmative steps that you can be required to do, and that's if they place an undue burden on your business or if it fundamentally alters the business. And like Linda was talking about, just as what is reasonable as an accommodation has changed as we've moved through the stay home, stay safe portion of the pandemic, some of that is going to have changed for our public accommodations as well. And so now I want to turn to some of the actions that businesses took during the stay home, stay safe portion of the pandemic, so that you can see what type of actions you can evaluate what you may have done in the past and how that may affect things going forward to you. So one action that a lot of businesses took in order to recapture revenue that's lost by the stay home, stay safe orders was to expand their websites or modify their websites. I know that a lot of restaurants, we'll get to this, have offered more takeout options, more drive-up pickup type of options, and we're going to hit that. But let's talk about websites, because from basically 2015 till through last year, there was a great expansion in the number of website lawsuits under Title III of the ADA. We've seen that level off at the end of 2019 and the beginning of 2020, but we're predicting that we could see another peak of these type of lawsuits. There's a confusing history to DOJ regulation of accessible websites. During the Obama administration, there was the DOJ promulgated some regulations about what would constitute an accessible website, allowing for public comment, and they indicated that they were going to be finalizing those regulations. And then after we had a change of administration, the DOJ withdrew those regulations, which never became final. At the same time, courts were processing a lot of lawsuits under the ADA for non-compliant websites. And to really cut to the chase on this issue, courts have found that websites are public accommodations, and that even if your business only has a web presence and doesn't have a brick and mortar facility presence, the vast majority of courts have found that websites must be accessible to persons with disabilities. So for most jurisdictions, including Texas, you can expect that to be the case. So what does it mean to have an accessible website? Well, there's a couple of things. Generally, when we think about an accessible website, we mean that a person who has a visual impairment can take an electronic screen reader and run it across the website in order to get the screen reader to give an auditory clue about what's going on. Essentially, the screen reader reads out loud the content of the website for a person with a visual disability to use. To the extent that your websites have video content, then for persons who have hearing impairments, you should make sure that that video content has been closed captioned or has subtitles on it. The standard is, unlike in the Title III context for parking lots where you have to have very specific measurements and there's thousands upon thousands of rules that you have to meet every one of them, the Web Content Accessibility Guidelines, or WCAG 2.0 AA, are not really a series of rules, but rather a set of standards that is not understandable to those of us who are not already familiar with coding websites. And so you're really going to need to talk to your outside providers who are helping you build websites about making sure that they're building those sites to comply with WCAG 2.0 AA. Again, like I said, because the confusing regulatory history, it's not been adopted, the regulatory standard hasn't been adopted under Title III of the ADA, but courts are applying it, and it's used in all DOJ settlements over websites, and also it's the legal standard for recipients of federal funds under Section 508 of the Rehabilitation Act. WCAG 2.1 is now available. If you have a WCAG 2.0 compliant site, that should be fine. Section WCAG 2.1 is basically to address apps. So let's turn to the what you should do if you've never thought about this with respect to your website. It's really difficult to eyeball compliance. I'm very familiar with many of the parking and path of travel requirements, and I can generally sort of drive through someone's parking lot and be able to eyeball whether or not we have compliance problems or not. It's very difficult to do that with the website, but there's a plethora of products that can audit your website without you even knowing it. So when you're taking a look at it, you may want to get an auditor to come out or use one of those products to take a look at your website and prioritize the most frequently used portions of your website first. Hire someone to make accessibility improvements to your website, and then really importantly, train your team on how to maintain accessibility as amendments and additions to the site are made. So it's a real shame to spend all the money to improve the site, but then have someone change out a few products and make the site non-compliant in its most recent iteration. And then you can audit on a regular basis. Okay, so a number of retailers, and let's take essential services like grocery stores, have taken actions in recent months and weeks to create special hours for at-risk groups to do shopping earlier in the morning before the store opens, but after it's been cleaned at the nighttime. While the definition of disability has not changed, people's general conceptions of whether or not they're disabled, and perhaps your conception about whether someone walking through a store is potentially disabled may have changed. So earlier, Linda mentioned that people over 65 have special protections under the state's orders. And we don't have to think about people over 65 as disabled, but they do have special vulnerabilities to COVID. So let's think about a person with cancer who is maybe immune deficient at this time. Immune deficiency would fall within the definition of disability. And so you should think there are certainly people who have cancer and other types of immunosuppressed conditions which will begin to think of themselves as, how am I going to be able to go out and use these businesses? And they may never have thought of themselves as having a disability before, but may start to think of themselves as that. So you may find people coming up to you and say, are you going to keep these special hours for the at-risk groups? And it's not that you necessarily have to keep the same hours as used during the stay home, stay safe, or even during this portion of phase one under the governor's orders. And you don't have to necessarily keep that until herd immunity is accomplished across the population. But like Linda mentioned, with respect to what is reasonable with respect to employees, what is reasonable with respect to the general public and customers with disabilities is probably also going to have shifted over time. And so you may want to think about how you're going to handle that as we move forward. Another action that businesses introduced was curbside pickup. So a lot of restaurants in particular and some retailers said, hey, we're still open for business in an essential service sense, that if you want to call and then come and pick up your groceries or your hardware or some plants, just give us a call and we'll drop them off at the curb for you and place them in your car. So that would generally occur at a brick and mortar facility, and as customers open, some customers may want to, as businesses open, some customers may want to continue to have such services, and they may or may not identify themselves when they're calling as having a disability. I think that with respect to curbside pickup, as we're in a phase in which retailers are not able to throw open the doors to anyone, any number of people who want to come in, but maybe only at 25% capacity or 33% capacity, you should think about whether or not during this phase in particular, it is particularly a reasonable accommodation to continue to offer curbside pickup for vulnerable populations. And that will shift over time. The governor will slowly allow more and more people to come in the stores, and maybe it'll become less and less reasonable of a modification. But that is going to be a difficult sliding scale that businesses are going to have to contend with as things go on. Also keep in mind, sorry, I forgot the most important part of this slide, which is that you can't charge more for policy accommodations or reasonable accommodations to customers with disabilities. So if you start imposing charges for curbside pickup, that is a danger slot for you with respect to customers with disabilities going forward. Another example of actions with potential accessibility issues are, in the past, some businesses have put up plexiglass barriers between customers and staff. That may mean that persons with hearing disabilities have more difficulty hearing. In addition to that, a lot of customers started to provide virtual services such as medical appointments, tutoring became virtual in a lot of instances, and virtual therapy services. So you may think about how, if that was a reasonable accommodation you could make in the past, how customers may start to ask for that going forward as well, and what you're going to do with respect to that. Policy modifications and rule enforcement are going to be the most ongoing aspect of ADA Title III. And just as some businesses are adopting policies for staff and customers with respect to personal protective equipment and social distancing, I think that you're going to find that more of your customers are going to ask managers to help enforce the rules that you adopt. And to the extent that you have adopted the policy, it's difficult to say that the policy or enforcement of it is unreasonable. In addition, I want you to think how customers are going to ask you to adopt or modify other policies or rules. So on some neighborhood websites, we're seeing that customers are asking for rules about no masks, no service, just as we had no shirt, no shoes, no service, that some customers could well ask you to adopt a no mask, no service policy. Don't be caught by surprise by this, and start thinking through how you want to do that. I also think that because, as Steve said, these rules are ever changing, and the information that customers are receiving, the general public is receiving about the virus and how to protect against it, is ever evolving, that you could see the request for policy modifications evolve as well. So I want to give you some ideas about how to think through the new normal of accessibility. Day one of phase one and phase two, and day one of phase three will not be a permanent situation. It means to be open is going to change, and the public is going to be hearing different bits of information, like I said. So if you think ahead of the standards that you're going to apply as your businesses start to fill up, and what you're going to do in order to keep both your employees and customers safe, or to make your customers feel like they should come back to your business, including customers with disabilities, you should think about how you're going to apply that. So as we fill up to 50%, what is my policy going to be on mask? As we get up to 75% and there's still no herd immunity, what am I going to do? If there's a spike in infections, what do I think I'm going to do with respect to my business and my customers? And then you need to think about how to train staff on accommodating customers with disabilities without asking intrusive questions. For most of you, this is going to be easy because you already are providing excellent customer service to your customers, and so you are going to be not really teaching staff about like how to provide good customer service, but how, if they have a customer saying, I'm in a vulnerable group, what can you have a mask policy, or can you go to that other customer over there and ask them to keep social distance? Teach your employees not to ask invasive or intrusive questions about the customer's health or their age or what their disability may be. and how they should go about enforcing rules. Frankly, we find that the best way to train staff on this is to really walk through and role play that issue so that they have actual lines that they can use and actual scripts that they can modify for themselves. And then also just communicate with the general public. I saw a lot of great communication from businesses about how they were staying open and staying safe. And you should communicate when those rules are changing and what the public can expect as they come back to your business. And then offer a way for customers to communicate their concerns with management and really be heard by management and engage those customers with their concerns so that you can be seen as accommodating and in really having an interactive process with them. So now I'm going to be turning it over to Tim to talk about what's next in COVID-19 wage and hour litigation. Tim?
Good morning. Thank you, Chris. On cue, someone with a very loud leaf blower just started blowing his leaf blower across the street, so I hope that's not going to interfere here. But yes, I'm talking about potential wage and hour litigation. I was talking to a plaintiff's lawyer friend of mine who reminded me that no catastrophe should go unlitigated. So I'm sure this is no exception, and there does seem to be the potential for a lot of potential lawsuits over various issues arising out of the pandemic and the disruption to the workforce. So the first category of cases that we're discussing is sort of obvious, what should be rather obvious problems that could arise, and we would hope wouldn't be a tremendous problem because they're pretty foreseeable. But the first one is just whether you've reduced a salaried employee's salary to the point where it's below the required level for the exemption. Obviously, if that happens, then that person is no longer exempt, and you would lose the exemption, and they would become overtime eligible for the work they're doing, and any hours over 40. So that's one, as I say, rather obvious situation. Another, perhaps less obvious and more likely situation is if you have a number of employees who you've decided should go on a reduced, you've decided to reduce their pay and reduce the amount of time that they work. That's fine, normally speaking. That is fine under the Fair Labor Standards Act. You're allowed to do that. There are a number of DOL opinion letters and cases discussing this. As long as this is not used as a subterfuge to try to get around the salary basis requirement, this is allowed. The example we give is if you have a 20% reduction in someone's salary and a 20% reduction and the amount of time that they're expected to work, that's acceptable. Really the only way that in order to violate to get within the category of cases that say that you violated the rule and you're using this as a subterfuge to get around the salary basis requirement, that would have to, for that to have to happen, you would have to change it from a salary basis 1 week, or change the amount of time 1 week and change the salary level 1 week and the next week, and flip-flop around just a significant amount in order to come within the risk of that. But if you just do it one time, or even once or twice, that shouldn't be a problem. The next subject in the salary basis or the salary level or exemption, I should say, exemption line of cases would be if you have a group of employees whose job duties change while they are, while they're working from home or while they're during the pandemic. If for whatever reason they may be working from home or other situations which would cause their duties to change. And again, there's case law that discusses this situation, and typically it is okay to have an exempt employee performing non-exempt duties for some period of time. The law is not entirely clear how long of a period of time that's acceptable. Generally speaking, if you're exceeding, say, a month where someone's duties have changed, then I think you're going to start to see the risk of a claim that someone has been converted from exempt to non-exempt. If you get beyond a month, I think you're running into significant risk on that. I think probably the biggest area of risk for employers is off-the-clock claims. Off-the-clock claims are difficult in the best of circumstances when you have employees working from home. And here we have a situation where we've got, theoretically, or I'm sure a number of employers have just, overnight have a tremendous portion of their workforce that is working from home, and there has been no preparation for it. There's been no consideration for it. No planning, no policies have been distributed or enacted to cover them. So that presents, I think, a pretty significant risk. When you have an off-the-clock claim by somebody who is working from home, that employee can say, they can testify or they can provide testimony about the hours that they worked, and it's very difficult to rebut that. So that has to be taken into consideration. And typically, if an employer has somebody working from home, they have considered all of the work duties that they're going to be doing and how long it will take and whether overtime is anticipated, and they're able to come up with a plan that anticipates that and controls for that. So that is a risk, and that could be a big challenge. And there's also going to be duties that people are doing that could arguably can be considered work, such as cleaning and sanitizing, putting on and taking off or donning and doffing protective equipment. Travel time is always a sticky issue when it comes to off-the-clock work, as well as training time. And again, here the idea is, or the thinking is that a number of employees are going to be going through a lot of training time in order to be able to work remotely and work from home, since they can't come to the office. We also think there could be a significant increase in what are typically state law claims. Although if we're in Texas, there's hardly any state law claims you can bring here, but obviously in other states there are a number of them, and one of the most prominent is employees working through their meal or rest breaks. Again, if employees are working remotely, it's very difficult to track and enforce a policy requiring employees to observe their meal and rest break and ensure that those meal and rest breaks are uninterrupted and are completely free of any work duties. There are commission and incentive plan claims that are often brought under state law claims. And if you have a commission incentive plan that may be sort of kicked into chaos in a remote working environment, that's something to take into consideration. And also, a lot of states have very technical and peculiar or technical esoteric laws regarding what business expenses have to be reimbursed. So if you have a number of employees who are working remotely, they may be incurring a number of additional expenses, internet expenses, phone expenses, data expenses, telephone expenses that they ordinarily are not having to pay under a number of states' laws. Those expenses may or may not be subject to reimbursement by the employer. Some other potential claims that we are expecting as a result are if there's layoffs, which obviously there are going to be and have been a significant number of layoffs and RIFs. And with any layoff and RIF, there's always a risk of a disparate impact claim or a disparate treatment claim. In addition to a lot of what Chris and Linda have already discussed about claims under the ADA and related claims under HIPAA, GINA, and other laws that regulate health-related issues like that. So a lot of people have been asking, when can we expect jury trials to return? And the answer is we don't know. I have my first hearing by Zoom with a court later today, and we'll see how that goes. But I don't expect, we don't know, but I just can't imagine that they're going to try to do anything beyond hearings without any significant witnesses or evidentiary issues by Zoom. So I'm guessing that jury trials will return when people can return to work safely and return to the courthouse, and the social distancing rules have been pretty much eliminated. You can imagine with litigation over the pandemic and disruption to people's lives, that the jury pool is going to have some significant, strong feelings about how this has been handled, how they've been treated, how they've experienced it, and those feelings and biases will obviously have to be addressed in jury selection. If someone has lost their job, has not been able to get unemployment compensation or get back to work, then that is one side of the spectrum that you're going to have to deal with in selecting a jury. If you've been in a management position and you've had to lose your job, or if you've had to participate in a RIF and make decisions about who is and who is not going to be included in a RIF, that is going to represent the other side of the spectrum, or could potentially. All of these things will be difficult and have to be explored in selecting a jury when you return. That's it for this section. Steve, I'll turn it back over to you.
Well, thank you, Tim. Let's close this out. I know we're going to run a couple of minutes late, but I'll go through my slides here fairly quickly. As everybody probably knows by now, the Families First Coronavirus Response Act was passed by the president back in March, and that law essentially requires employers with 500 or less employees to provide paid sick and paid family leave for COVID-19 related reasons, right? the law is, we know, will be with us through the end of the year. But depending on what happens during the election later this year, and depending on how the country handles the ongoing pandemic, there's certainly a chance that the legislation will be extended into 2021. And so we have obviously 6.5 months remaining, and potentially even more into next year. It's really now is the right time, as your employees return to work, to brush up on the FFCRA. When it was originally passed, a few weeks later, the Department of Labor came out with some FAQs on the new law, and I think the original FAQs had about 20 or so. Then they published another 15, then another 15, then another 20, and now we're up to 88 FAQs on the Department of Labor's website. And I can tell you, I've read them all. By number 58 and 65, my eyes started to gloss over, but I did get through them. And here are some tips and traps that I found in the FAQs. Now, employers are typically used to providing paid sick leave or family leave, but only after the employee has worked a certain amount of time. The trap with the FFCRA is that with respect to paid sick leave, the employees are eligible immediately on their first day of work. So you may have an employee, a new hire, for example, a month or two from now, and you do the onboarding and you offer them the job, and between that time and their first day of work, they get exposed or they have to take care of somebody at their household, and they would qualify for paid sick leave, even starting on their first day. We know a lot of employers haven't put up posters yet, right? That's an item to put on your checklist. There's a Department of Labor approved poster that you have to put up. And if you can't put it up already, or you have employees that are continuing to work remotely, then you have to distribute it by email or put it on an intranet site. One interesting item, as schools are closing for the school year, it's important to know that under the law, you may be required to provide childcare leave to your employees that go beyond the end of the school year, right? So think about daycare age children or summer camps. The law, the definition of a place of care, right, under the law is very broad, and it does include things like summer camps that are also closed. Another clarification, and employees may be confused about this, but the law doesn't entitle employees to an extra 12 weeks of family medical leave, right? So when you're calculating FMLA, let's say you have an employee that wants to take expanded or extended FMLA under the new law tomorrow, and they only have 5 weeks left, right? Because they took FMLA earlier in the year, or whatever your look back period is, or whatever the way that your company calculates FMLA. There's a couple of different ways to do that under the regulations. Well, that employee starts with 5 weeks left, and then you subtract from there. Another tricky item is, what if I have an employee who wants to take FMLA for their own serious condition, and maybe what if it's related or because of COVID-19, right? For example, somebody who was previously tested positive is no longer positive, but has had some health complications because of that, heart issues, breathing problems, right? In that case, they wouldn't qualify for paid family leave under the law. It would qualify under the regular FMLA leave rules, and that leave would be unpaid, of course, unless you have a company policy to provide for payment during unpaid FMLA periods. A couple of other interesting tidbits. What if you have employees that are out on workers' comp or short-term disability? Do they qualify for paid leave under the law? The answer is probably not, right? Unless they were able to return to work on light duty before taking the leave, right? So, for example, you've probably heard that eligibility under FFCRA essentially requires the employee to have work to do or to be able to work, right? So furloughed workers, for example, are not eligible for leave under the FFCRA. the same rule essentially applies to employees on workers' comp or short-term disability. If they are unable to work, then they would not qualify. Another tip here in terms of compliance, think about whether the employee may qualify for intermittent FFCRA leave, right? So that's not mandatory, but an employer can approve intermittent FFCRA leave, right? And there's different rules that you have to look out to watch out for depending on whether the employee is telecommuting at home or is working on site. And why would you want to consider intermittent leave or approving intermittent leave? Well, you might have an employee that is essential, right? Or the employee may want to continue working for some period of time and earn a higher wage, right? So you can accommodate those kinds of requests. A couple of last tidbits here on the slide. For those of you who are curious, there's not going to be any year-end carryover, right, for emergency paid sick leave or even the extended paid family leave, right? The law expires, sunsets at the end of the year. And again, there's no payout on termination of emergency paid sick leave benefits, even if that's without cause or layoff. So I thought those were interesting. You have links there at the bottom left of the slide for additional resources, including a link to the 80 or so FAQs. And where can you find some more resources? Well, like I said, we've done a lot of the hard work for you. We've got the firm. We've been working on a pretty extensive resource center that has templates and guides and articles and best practices advice. We are putting out daily updates on all things COVID related in multiple jurisdictions across the country, safety issues, compliance, return to work checklists, stay-at-home orders, all of those kinds of things on a daily basis. We are sending out updates. Feel free to sign up. We also have a dedicated sort of cheat sheet for helping employers to return to work. That's the third website there. It's about a 30-page document, a great start. And last but not least, we have collected all of our COVID webinars so far. We're up to 21 in a website for you to browse and listen to at your leisure. We've covered a number of different topics today, but we've also done specific webinars on individual topics, right? Safety, 50 minutes on safety, FFCRA compliance, a full hour on FFCRA, other specific webinars. So if you're interested in learning more and getting into the details of all of these topics, feel free to check out our webinars. So we thank you for staying with us for a couple more minutes. We apologize for going over. We really thank you for joining us. We hope everybody is safe, returns to work safe, and we can get Texas reopened. Thank you very much, and have a great day from all of us here at Seyfarth.